I watched my mother-in-law, Patricia, lean across the spectator row and let out a sharp, mocking chuckle. She leaned close to her son Stephen, making sure her voice carried across the silent courtroom as she pointed directly at my empty table. "Look at her," she sneered, "she could not even afford a lawyer." I sat quietly, resting my hands on a worn brown leather folder, completely unbothered by the quiet chuckles rippling behind her. Then the side door opened, Judge Harold Whitmore stepped up to the bench, locked eyes with me, and said in a clear, resonant voice, "Good morning, Colonel Bennett." The entire room went dead silent, and Patricia's smug grin vanished so fast it was almost comical. She looked around in utter confusion, staring at the judge and then back at me as if waiting for someone to reveal a hidden joke. But nobody laughed. "My name is Laura Bennett, and for 2 decades, I served as an officer and top prosecutor in the United States Army Judge Advocate General Corps. When I retired 3 years ago, I intentionally left that life behind, settling into a quiet routine in Richmond, Virginia, to give my 11-year-old daughter, Emma, a normal, peaceful upbringing after the devastating loss of my husband, Daniel. Daniel had been a National Guard helicopter pilot, and when an equipment failure took his life during a routine training exercise, our world shattered. In the immediate aftermath, Patricia and her husband Richard acted like supportive grandparents, bringing over meals and mourning alongside us at Arlington. But as time passed, grief turned into resentment, and Patricia began dropping subtle, poisonous comments about my parenting and my past. She assumed my quiet nature meant I was weak, and because I rarely talked about my time in the service, she convinced herself I had been nothing more than an unimportant military clerk. Over the next 2 years, those passive-aggressive remarks spiraled into outright hostility as Patricia started spreading rumors that military service had left me emotionally unstable. She constantly criticized my modest lifestyle, completely oblivious to the fact that between my military pension, survivor benefits, and personal savings, I was financially secure and simply preferred a quiet life. The tipping point arrived 6 weeks ago when a certified letter landed on my doorstep. Patricia had hired the most ruthless family law firm in the city, filing a petition for full custody of Emma while claiming I was an unfit, secretive mother who was mismanaging Daniel's financial estate. Reading those absurd allegations, I realized Patricia was mistaking my silence for vulnerability and my privacy for guilt. Instead of spending tens of thousands of dollars on a high-powered trial attorney, I decided to handle the case myself, packing my old trial prep notes into the leather folder I had used during my time as a senior prosecutor. Patricia walked into court expecting an easy victory against a grieving, helpless widow, completely unaware that she was stepping into an arena I had mastered over 20 long years of high-stakes military litigation. When the hearing formally began, Patricia's expensive attorney, Charles Donovan, took the podium and began building a narrative centered entirely around my supposed emotional detachment. He argued that my unwillingness to discuss my past was proof of deep psychological trauma, claiming my quiet lifestyle was actively harming Emma's development. I sat calmly at the defense table without interrupting, writing precise notes on a yellow legal pad while allowing him to exhaust his arguments. When the judge asked if I wished to make an opening statement, I simply stood up and stated that my evidence would speak far louder than any speech. During a brief afternoon recess, I stepped into the marble hallway where Patricia immediately confronted me, demanding to know why the court staff and the judge kept addressing me as Colonel. I looked at her calmly and explained that I had spent 20 years handling complex court-martial prosecutions, war crimes, and high-level military investigations. Her face drained of color as she processed the realization that the quiet daughter-in-law she had spent years patronizing was actually a seasoned federal trial attorney. She tried to ask more questions, but the bailiff called us back inside before she could recover her composure. When court resumed, Donovan called Patricia to the witness stand to establish her claims that I was isolating Emma from the family. Under his guided questioning, Patricia played the role of a worried grandmother, tearfully testifying that I constantly kept Emma away from family gatherings and maintained an unnerving level of secrecy about my life. Donovan handed her over for cross-examination with a confident smile, believing he had successfully painted me as an emotionally cold and distant mother. I approached the podium holding only my pad, keeping my voice soft, polite, and completely conversational. I asked Patricia to clarify how many times she had reached out to see Emma over the previous year, to which she claimed she could not recall. I opened my records and pointed out that out of 23 formal invitations I had extended to her for dinners, birthdays, and school concerts, she had voluntarily declined 17 of them to go on vacations and social trips. The courtroom gallery began to murmur as Patricia stammered, forced to admit on the record that her lack of contact with Emma was entirely her own choice. Next, I methodically dismantled her claims regarding Emma's well-being by walking her through official records showing Emma's stellar academic performance, active participation in youth sports, and continuous progress in grief counseling. Patricia was forced to agree with every single fact, effectively demolishing her own legal argument that Emma was suffering or neglected under my care. By the time I asked her if she had ever once bothered to ask her late son or me about my actual military career before making assumptions, she could only stare down at her hands in silence. To deliver the final blow, I submitted certified financial audits from the bank demonstrating that every penny of Daniel's survivor benefits had been placed into an untouchable trust fund for Emma's college education. I also presented my own verified financial statements, proving beyond any doubt that I supported our household entirely on my own earned income without touching a single cent of my daughter's inheritance. Donovan looked over the documents, realized his entire petition was built on baseless assumptions, and quietly sat down without offering a redirect. Judge Whitmore looked down at the court records, then turned his attention directly toward Patricia and her legal counsel. He stated firmly that the petition was not only completely devoid of legal merit, but that bringing such unsubstantiated claims against a dedicated mother was an egregious waste of the court's time. He formally dismissed the case with prejudice, ordering Patricia to pay every single cent of my court costs and filing fees. Patricia sat frozen in the witness box, completely stripped of her arrogance as the reality of her self-inflicted defeat settled over her. As I packed my leather folder and walked out of the courtroom into the afternoon sunlight, I felt a deep sense of relief washing over me. I drove home, greeted Max at the front door, and wrapped my arms around Emma, knowing that our quiet, peaceful life was finally safe, and that real strength never needs to shout to be heard.